husband's petition for grant of interim maintenance, which has been challenged. The impugned order.
Where is the order? Page number?
Impugned order is at page number
74, Your Lordship.
174.
170.
174. But I'm agreed with two facts, madam. First is, Lord, there is a substantial amount which has been paid by me.
1 minute. Let me just see what is the order.
Please.
How much is granted?
35,000 per month.
35,000 to both wife and
Child. One child.
What is your income?
My income is 1,85,000.
1,85,000.
Please. I have two dependents who are my parents for age.
So in every
And
case,
moreover, my lord, my loans are running more than 1,30,000 per month. For your lordship's
loans you have taken.
house loan, my lord, there's a joint property which I and my father own, and out of which there's a 38 lakhs outstanding loan is there on that property, my lord, which is for which I am paying an EMI of rupees 90,000 and odd. And apart from this, I have few medical loans, my lord, where I am treating my father and my mother for their medical expenses. Those loans are pending, my lord. Now, my lord, why I am agreed with this order is that, my lord, whatever I have paid, substantial amount. I mean, even if it's considered, 11,55,000 will be the total amount due, my lord. Out of which more than about 6 lakhs is already paid. I think even my learned friend acknowledges the same of it.
So we are not on the interim, whether you are paid or not paid, that we are not looking at.
Please.
We are looking at whether this order is right or wrong.
Please, that's one part. First part, my lord, whatever I've paid is not considered in this.
Decided by the trial court. Let him file a memo, calculation,
I'll file
everything will be decided.
That's first part, my lord. Second, my lord, kindly request you to go to page number 175, my lord.
Yes.
Page number 175, Lord, the first paragraph. After remanding the matter, the petitioner has furnished a fresh affidavit of assets and liabilities with bank statement commencing from July 2022 to February 2025. Lord, the date of the IA is July 2022, my lord. Now, when the date of the IA is July 2022, as per Rajneesh versus Neha, he has to file 3 years bank statement prior to the date of IA, wherein she has filed it from July 2022 to 2025, which I am agreed with.
Where is your case that she's earning?
But she's not earning. She's a BCom graduate.
Then?
Oh, my lord. It's a whole short point, my lord. And
that is, it's a purely technical issue. Is it your case that the wife is earning and still she is seeking maintenance from you? Where did you say so?
No, I'm not saying.
So how does it come in the way?
I'm not saying for a moment, my lord.
No, on this, why should the order be set aside?
Look, what I'm agreed with, my lord, there's a perjury application which I have filed before the trial court. There are two types of perjuries which has been committed. One, my lord, with respect to pendency of the old cases. There were few cases which were pending before me and the respondent wife. And those cases were not disclosed before the honorable trial court when she filed her assets and liabilities. That's the first ground, my lord. And with respect to the address what she is given before the trial court for filing the petition, my lord, that also comes to be false. And I find out, and she also files her objections to that perjury application, wherein she admits, yes, I'm not residing in that address.
That will be decided.
But my perjury application, my lord, is still not passed. There's no order passed till now, my lord.
Please restrict your arguments to this idea.
Or
how is it right, wrong? I am not going into any other aspect.
I only
granting 35,000 is on the higher side. Only one.
Yes.
Only argument on that.
My only grievance is, my lord, now, my lord, the loans run more than 1,30,000.
Why did you take?
Housing loan is there, which is a joint property. It's not my property.
So you're enjoying it.
No, my lord. My father is taking the rent of it.
Then why are you paying that much of?
So I'm just supporting my father, my lord. Sorry. I'll restrict to this, my lord. Whatever I've paid, more than half of the amount which is pending is already paid. Let that portion be calculated by the trial court and let there be a consideration of it, because
no, we'll not consider anything. 35 is a reasonable amount.
35. I'm not disputing about the quantum of the amount which has been ordered, my lord. My only grievance is when the total amount is 11,55,000 and where I've paid to the money to the tune of.
I said already. We will confirm this order as far as the amounts that are paid or not paid. Please. Both of you file your respective memos.
Yes,
court will look into it.
Yes, sir.
Let that be considered, my lord. The only grievance is, my lord, when
it will not be considered.
Because in the order it's not mentioned explicitly, my lord. That's the whole concern. They've only told pay 35,000 from the date of IA.
Whatever is given, it goes without say. If you have already paid, that will be that amount will be considered.
That amount has been, my lord, in fact recorded in the order sheet.
Yes, please come.
Not considered.
Yes,
The whole consent.
I agree with the orders passed in I number 2 in criminal miscellaneous number 531 of 2022, whereby the court had granted 35,000 as maintenance. The husband is before this, maintenance to the wife and the daughter. The husband is before this court. The admitted facts in this case are that the wife is not working. The husband salary is 1,85,000. It's a case of the husband that a substantial amount of 1 lakh is paying towards the EMI, and also he has to take care of his old age parents, and also he's paying the amounts towards the medical insurance, medical expenses for both the parents. It is further submitted that he has paid several amounts, and the court had passed an order wherein the court has observed that it says the respondent is directed to pay arrears of maintenance. What else you want? Arrears means what?
It is pending.
My lord, in fact, I have brought it to the notice of the trial court that I have paid this
It is
amount.
only just for buying some time you have come to this.
No, my lord, I'm still
The
paying.
respondent is directed to pay arrears of maintenance within 3 months from the date of the order.
That's all.
The submission of the learned counsel for the petitioner is that he has already paid certain amounts. Now, by virtue of this order, those amounts which were already paid by the petitioner are not at all looked into by the court. And his apprehension is that he may have to pay the entire, the order of the court is without even deducting the amounts that are already paid. He'll be made to pay the entire 35,000. Next parallel, and counsel appearing to the respondent submits that the court, considering the financial capacity of the husband, has rightly granted an amount of rupees 35,000 towards the maintenance, and there are no reasons to interfere. Next para, having heard the counsels on either side, there is a material on record. Considering the income of the husband and looking at his financial capacity, the court had rightly granted an amount of rupees 35,000, and this court and no interference is called for. Then coming to the contention of the learned counsel with regard to the amounts paid, the order of the court is very clear. The amount is 35,000 per month. If any amount that is paid by the petitioner will be deducted, and the remaining amount he has to pay as per the order of the court. Both the parties, within 10 days from the date of the order, both the parties shall file their memo of calculation, and basing on that, within 1 month from that date, from the determination about what are the arrears, the amount the petitioner shall pay within 1 month from there on, and shall continue to pay by 10th of every month.